Hi, everybody. Welcome. Welcome to True Crime Wednesday. We have a lot to talk about tonight. Hey, first of all, sorry that I thought I was getting ahead of myself and creating the stream for tonight yesterday and made the mistake of not double checking the date. So for anybody who got faked out and thought we were going to be on tomorrow or on yesterday, I'm sorry, but here we are. So welcome. For anybody who's new to the channel, my name is Lori Hullis. I am a retired criminal attorney, and I'm retired to write, and I am writing a book about the Vallow Daybell case, which we hope we're going to be launching here in the very near future. So welcome. And we have plenty to chat about tonight. So let me grab my notes and let's talk about, I don't know if anybody's been watching the Crumbly trial, but we're going to talk about that in a little bit. First of all, I always like to start with the Vallow Daybell case because that's the one near and dear to our hearts. That's how a lot of you found me to begin with. And so I want to chat about that a little bit. First of all, I'm going to get my telephone muted so that we don't have my phone ringing while I'm in the middle of this. First of all, you all know that Chad Daybell's trial is coming up the first part of April. I would not at all be surprised to see Chad Daybell's attorney file to postpone the trial yet again. I don't believe that the judge is going to allow that. He wouldn't permit John Pryor to withdraw, and I don't believe he's going to permit the trial to be set over any further. I did see that there was a request for additional time for John Pryor to be required to provide the prosecution with his witness list of his expert witnesses and the associated reports. That was filed yesterday, but that's all I've seen that are any recent filings. We're still hearing rumors that there may be plea negotiations going on, so we'll wait to see. But I'm not sure that Chad is going to be willing to enter a plea. I just don't think that he is very, I don't think that he is very grounded in the reality of his situation. I think that he is still, hoping against hope that he can somehow wiggle out of this. So Lori's appeal, they have the court reporters have requested extra time because they are creating the transcript of the trial, and that is a very labor-intensive job. And so it's no surprise that with a 6-week trial to transpose that they are asking for some extra time. And then Lori's trial in Arizona. So I looked that up today. She had a scheduling hearing on the 19th, which I think was, I don't even know whether it was streamed, but it was very brief. And she is scheduled for another scheduling conference on the 21st of February at 8:30. And the notice that was the court minutes that were filed reflect that September 2nd of this year is the last day in her speedy trial window. So, so we will wait to see whether or not they're prepared at this point to schedule a trial. Excuse me. But I suspect we might see a trial date when that February date rolls around. Well, and we had big news in Murdaugh. We had the evidentiary hearing was held on Monday, and that was very interesting. Justice Toll, who is the uh, retired Supreme Court Chief Justice from the South Carolina Supreme Court presided. She was very she was very clear about what the parameters were that she was going to observe during the evidentiary hearing. And I will say that she did give the defense a little more leeway than I actually expected. So here's the biggest issue, and it continued to be the biggest issue even after she announced how she would be the legal standard that she would be using to decide the issue. And that is that there is a U.S. Supreme Court from 1954 called Remmer. And in that case, the U.S. Supreme Court said that if the defense established that there was a possibility of jury tampering, then there was a rebuttable presumption of prejudice, meaning if something happened that could have impacted the jury, it was presumed prejudice, and then the prosecution had to prove there was no harm. That's what's called burden shifting. So in general, the law is very clear about who has the burden to prove any given issue before the court. So in the case of a criminal case, we say the prosecution has the absolute burden to prove beyond a reasonable doubt that the person is guilty. So burdens of proof vary depending on the type of issue that is being decided. But in general, courts don't like shifting the burden from one side to another. So the moving party generally has the burden to prove their case, and courts don't really like mechanisms that shift the burden to somebody who wouldn't normally have it. And that's what Remmer did. Remmer said, we're going to presume prejudice if the defense puts on a prima facie case, a basic fundamental case that there has been some sort of jury interference, then we're going to presume that it was prejudicial unless the prosecution proves otherwise. Well, a lot of courts, including several of the federal circuits, have moved away from that to saying, no, there needs to be proof that there was actual prejudice. It's not enough to say we're going to presume there was prejudice. Now, the South Carolina circuit, the Fourth Circuit, has not adopted that. The South Carolina Federal Circuit still relies on Remmer. However, the South Carolina Supreme Court, the state Supreme Court, has adopted the non-Remmer prejudice is required rule. And that comes from a case called Green. So when we got to the preliminary hearing, to the preliminary scheduling hearing last week before last, or actually last week, the judge made clear that she was not going to apply the Remmer standard, that she was not going to require, she was not going to presume there had been prejudice, and that the defense would actually have to prove that Alec Murdaugh had been prejudiced by the contact with the jury. So, and that is the standard in the state Supreme Court case, Green. So what she said was that the South Carolina case controlled her decision-making in South Carolina. And she seemed pretty confident that that was the way she was going to rule. Now, if the case were to be elevated to the federal Supreme Court, it's a little unclear about what the Fourth Circuit would do, because they have yet to distinguish or do away with Remmer. Some of the other federal circuits have. So, but I thought it was interesting because Judge Toll was the Chief Justice of the Supreme Court. If anybody has their finger on the pulse of the South Carolina Supreme Court, you would think that it would be her. And she very confidently said that that was the legal standard that she was going to apply. She also initially told everyone that she was going to limit the witnesses who were going to be brought in to testify. So what happened was there was one of the 12 jurors who for some reason was not going to be available on the day of the hearing on Monday. So they took her testimony on Friday, and a lot of people had a lot to say about the fact that that was not live streamed. The reason was because they had the jury sequestered, meaning those witnesses were going to be called in one at a time. They were not going to be able to hear what anybody else had to say. And they were going to have their testimony taken while it was unimpacted by anybody else's testimony. However, that didn't last very long, but we'll get to that in a minute. So they took that juror's testimony, and then on Monday they opened up the record. It was live streamed, and they brought in each jury in turn. So all of the 11 other jurors, they brought them in. The judge had a series of questions that she asked. She asked the same questions for everyone that was there, each one of those jurors. And essentially she asked, did you hear any statements that Miss Becky made? And if so, did they impact your decision-making? There were only a couple of the witnesses who said they had actually heard Miss Becky say those things. And each one of them said, no, it did not impact my decision, with the exception of one juror. This was the juror that Harpootlian and Griffin were counting on. And this was the juror who said her initial affidavit said she felt pressured in the jury room by other jurors. Now, this is very different from being influenced or pressured by the clerk of the court. It is very typical for people to get into a jury room and for there to be discussions and people trying to convince each other and perhaps pressure one another to make a decision. That is very typical a very typical occurrence in a jury, and the parties are specifically forbidden to ask about the substance of juror deliberations. So later she said, yes, I felt influenced or pressured because of the things that Miss Becky said. The judge didn't appear to give that a whole lot of credence, mostly because her statements had changed from her affidavit to her court statement to an affidavit that was filed the same day by her lawyer. So her testimony was a bit of a moving target, and I think that the judge didn't find it very credible and discounted it. Now, in this case, the judge was the trier of fact, meaning it was the judge who had to weigh the credibility of each of the witnesses. So following that, they called Miss Becky. Now, Dick Harpootlian had wanted to call two other jurors who were alternates. One was an alternate, one was the egg lady, who contended that Miss Becky had made the statements that they said she had made. There were some other allegations about whether or not Miss Becky had given a juror a ride home, some other questions. Now, Becky Hill categorically denied that she ever said directly to the witnesses, to the jury, Alec Murdaugh's going to testify, watch his body language, all of those things. She did say that she came into the jury room and said to the bailiff, Murdaugh's going to testify, and may have said, pay attention, this is important, or something along that line. She felt that she was doing that to pep up the jurors who were getting tired, and it was a 6-week trial, and they were just sort of running out of attention. So Justice Toll then asked her own series of questions of Becky Hill, and both sides were allowed to cross-examine. And then she allowed Dick Harpootlian to bring in the alternate juror. She didn't allow him to bring in the egg lady, but she did allow Harpootlian to bring in that alternate juror who said that she had heard Becky Hill make certain statements. Justice Toll also allowed Dick Harpootlian to bring in the clerk of the court from a different jurisdiction who had been there to assist Becky Hill while the trial was going on. And she knows the responsibilities of a clerk of the court, and was said that she was concerned about some of Becky's behavior. So ultimately, what the judge said was, Becky Hill was seduced by the siren song of celebrity, I think was what she said. And many of the things that she did in furtherance of that celebrity was inappropriate. But it did not prejudice the jury, because the jury very clearly said, we were not influenced by anything we heard Becky Hill say. Not every one of them said they heard her say anything, but the ones that did said it didn't influence my decision, with the exception of the first one on Monday, who the judge appeared to have found less than credible. So, and that credibility decision is a decision that is the purview, the responsibility of the trial judge in a hearing like this. If it were a trial where there was a jury, it would be up to the jury to determine the credibility of a witness. But in this sort of a case where it's not a jury trial, it is a hearing, it's the judge's responsibility to determine the credibility of the witnesses. So ultimately, the judge found that Alec Murdaugh had, the jury, there was not actual prejudice to him based on juror misconduct, and she denied the motion for his new trial. Now, I'm certain that this is going to be an appellate issue that is going to go up through the South Carolina Appeals Court and perhaps even to the U.S. Supreme Court. And it will wind its way through that process, and it probably won't, the decisions won't be made until we're all long retired. So there is no chance at this point that Alec Murdaugh is going to get a new trial. He is going to continue to serve his life in prison without parole sentence. And the appeal from Justice Toll's decision this week will wind its way through the appellate court on the slow boat that most appeals are on. So last week, somebody asked me about Bob Menendez. Now, I don't usually comment on political matters. I have gone out of my way not to comment on former President Trump's legal battles, and I really do not want to get deeply into this, but there was a question having to do with search warrants. And for those of you who are not familiar, Bob Menendez is a Democratic senator from New Jersey. He was arrested after a lengthy investigation into allegations that he took bribes. So he previously had been prosecuted in a bribery case that ended in a hung jury and wasn't retried. And so his position is that prior prosecution, that they're just trying to get even with him because they weren't successful the first time. However, they served a search warrant on his home. They found cash and gold bars and a luxury car and a bunch of other things that made it suspiciously look like he was accepting bribes. And he claims that the search warrant was not valid. So I wanted to talk a little bit about search warrants. We also have seen a recent challenge in the search warrant in the Delphi case. So I want to talk about what it takes to get a search warrant. So law enforcement creates an affidavit and they take it to a judge, and a judge either approves or disapproves the search warrant. So a judge could say, yes, I think there's enough here, and you can go, I'm signing the warrant that you can go and exercise the warrant on these people's property. Or a judge might say, I don't think you got enough here. So in the case of the Menendez case, what they're saying is one of the rules about warrants is that the police have to state with particularity, is the word, what it is that they are looking for in the home, in the premises that they are searching. And it's not enough to just say all evidence of crime. Well, that could be anything. They have to say money or documents, electronics that would prove that this person engaged in a scheme, a bribery scheme, or accepted bribes, and and they have to outline what those things are: gold or money or electronic documents that would show correspondence with the person who bribed them. And they do have to be somewhat specific. And so the police are always kind of walking the tightrope of being specific enough to meet the judge's requirements and general enough that they can use what they get or what they find. So in this case, Senator Menendez has claimed that the warrant was not specific enough, and that because of that, it was an illegal search. And so everything that was seized as a result of that search is fruit of the poisonous tree and would have to be suppressed as well. No decision's been made on that case, but he is challenging the warrant. We've seen that also in the Delphi case, where the Delphi attorneys, the original Rosie and Baldwin, have claimed that the law enforcement did not disclose other theories of the case or the lack of connection to Richard Allen. So, and they've asked for a hearing on that, and the judge denied the motion with no hearing. So that we'll get to Delphi in a minute, because there's a lot more going on in Delphi. But I did want to talk a little bit about Menendez and search warrants. So let's move on to Delphi and talk about that case. Now, on the 18th of January, the Indiana Supreme Court held oral arguments and heard the motions that Rosie and Baldwin, the original attorneys, had filed on Richard Allen's behalf. And in a move that is absolutely unprecedented, within 2 hours of the close of the oral arguments, the Indiana Supreme Court issued a ruling saying, reinstate Rosie and Baldwin. That's just, it's absolutely unheard of. So everyone who's been following the case was absolutely stunned, including the people who were in the courtroom. And but the judge, the Supreme Court did say that they were going to issue a full opinion. It just, the order to reinstate the two attorneys was an interim. So we have not seen the court's complete decision or understood what the reasoning is, because the Supreme Court's decision really outlines their reasoning so that other people can follow it like a roadmap. And so we have not seen the court's reasoning on the reason why they made the decisions that they did. Now, they had asked for two other things. They'd asked for an accelerated trial date, and they'd also asked for Judge Frances Gull, who it was the retired judge appointed on the case, to be disqualified. Actually, I don't think she's retired. I think she's a senior judge, but I don't think she's retired. So they asked for her to be disqualified. The Supreme Court denied both those motions, but we don't really know why the Supreme Court denied them, what the reasoning was behind that. So Rosie and Baldwin then refiled their motion to recuse the judge. Now, it's a little bit of a strange situation within the state of Indiana, because in Indiana, the trial judge is the one who decides whether or not a recusal is appropriate. And that's Judge Gull. So in a lot of other states, if an attorney asks for a recusal, that motion goes usually to the presiding judge of the jurisdiction, who then makes the decision. But to be really honest, in most cases, if you file a motion to recuse a judge, it's very likely the judge is going to recuse themselves, because they do not want to sit on a case where they could be accused of having some level of bias. So it is a little surprising that Judge Gull has been so tenacious about staying on this case. So Rosie and Baldwin have yet again filed their motion to disqualify the judge. The very next day, the prosecution filed a motion for contempt against Rosie and Baldwin for the leak of the crime scene photos. Now, it appears that this is purely retaliatory. I mean, I can't imagine anybody not seeing this as plain and pure retaliation, because the motion just basically says we want them fined, held in contempt, and the bottom line is they couldn't get them off the case, so now they're gonna try and get them disqualified because of them being in contempt of court. So if you look at the contempt statute, the motion is for indirect contempt. So what that means is it's direct contempt if you're in court and you mouth off to the judge. It's indirect contempt if you violate a court order that the judge has entered, which is what they're alleging was done, that they violated the gag order and the orders to keep the discovery materials protected and private. So the statutes require that they be willful, that there be a willful violation. And you have to prove something more than it was negligence. Willful means that you have to do something in furtherance of that. And I don't believe they can prove willful, that there were any willful acts on the part of Rosie and Baldwin. And I think this is just pure retaliation. And it is I think it's interesting that the prosecution is retaliating in this fashion. I think that they have been, not only Judge Gull, but the prosecution has been called into question for the way that they have furthered this case, in spite of the fact that there's ample evidence that Richard Allen is not their guy. And I think they're filing it as a way of just one-upping. So I think it will be interesting to see the basis on which the court ruled, the Supreme Court in Indiana ruled. And I think that will give Rossi and Rosie is the way he pronounces it, and Baldwin both a much better roadmap for where they're going with this case. Interestingly enough, one of the two attorneys who Judge Gull appointed when she removed Rosie and Baldwin has come out and said, we think Richard Allen is innocent too. And we think that Baldwin and Rosie have a very good argument about why they believe that he was improperly targeted. So I think it's really interesting. These are really important issues. And I think it points out we are seeing this. And I wonder if it's just the sunlight of so many creators who are really digging deeply into these cases. Say what you will about the true crime community, or people who are interested in true crime, or who are creating in the true crime area. But I think that they're actually pretty well intentioned, and you have several lawyer creators who have been very critical of the way that the prosecution and judges are in bed together sometimes. So we have Indiana, we have South Carolina, we have Florida, we've got cases coming up in we've got Idaho. We've got some other cases that are going to be coming up on whether or not prosecution is too closely aligned with the court, or the court is too closely aligned with the prosecution. It was a very interesting interview on Law and Crime with Jesse Weber, interviewing the judge who presided over the Parkland high school shootings. And she was actually removed because of her behavior in court and her clear preference for the prosecution. Interestingly enough, in that interview, she just doubled down on the defense, and in a very unprofessional and unbecoming way, I think. And that sort of leads me into Crumbly, but I did want to make mention of one thing before we move into Crumbly, because a lot of people have sent me questions about the woman who is providing the defense in the Crumbly case. And I do want to talk about that. But before I jump into that, I do want to mention we've had some developments around death penalty and specifically executions in death penalty cases. Recently we had the state of Idaho reinstate the firing squad as an alternative method of execution because of the shortage in lethal injection drugs, the availability of those drugs, and the fact that a lot of companies who manufacture those drugs refused to sell them to states for the purpose of carrying out executions. The state of Texas has gotten around that by going to compounding pharmacies with some less than stellar results. And now the state of Missouri, my goodness, I thought I had this in my notes, recently carried out an execution by causing the person to breathe pure nitrogen gas until they suffocated. People who were there and witnessed the execution said it was absolutely horrific, that the person struggled and was horrible. Now, I understand that there is a difference in the way that people view the death penalty. And I have always been very cautious not to express my own views. Y'all know I'm a defense attorney, so I think you can jump to whatever conclusion you want. But our Supreme Court says, our US Supreme Court has said, executions, the death penalty is legal in our country as long as it is not cruel or inhuman. And I realize that there are a lot of people who think that when a person is executed, they deserve to suffer to the same level as their victims. I understand that that is a position a lot of people take, but that is not the state of our law. Our law says that you may not impose a death penalty and you may not execute someone in a manner that is cruel or inhuman. And it seems to me that someone struggling, jerking, thrashing for minutes while they slowly suffocated is too awful to really even contemplate. Say what you may about the death penalty, pro or con. We have a moral obligation and a legal obligation to make sure that executions are carried out in a humane way. And to my way of thinking, that did not comport with the Supreme Court's guidance on executions. So I think that there's going to be an awful lot of conversation about whether or not future executions will go that way. I think it may. Well, I'm not going to even speculate at this point. If somebody knows what state it was, drop it in the chat, because I thought I'd written it in my notes when I was doing my research. That state announced that they believed that they would be giving other states advice on how to carry out nitrogen executions. And I thought to myself, yeah, I don't think so. I don't think that there are any other states that are going to. Oh, Alabama. Thank you, Janet. I don't think there are any other states that are going to be jumping to carry out executions in that fashion. Not after that. Now I want to jump into Crumbly. Today was day 5 of the Crumbly trial. Sorry. And it is very interesting. I will say that. The Crumblys are the parents of, and only the mother, Jennifer, is on trial. The parents' trials were severed. So Ethan Crumbly is a school shooter. The details of the case are awful. Um, this is a very unusual case. This is a case of what we call first impression, meaning there's no precedent for this. And what occurred was that the state believed that the Crumbly parents had been so grossly negligent in their parenting that it rose to the level of contributing to the murders. It is not typical for parents to be charged for the behavior of their children. Ethan Crumbly was 15 at the time that he carried out the crime. He was remanded to adult court. He was prosecuted as an adult, and he entered a guilty plea and was sentenced to life without parole as an adult. The U.S. Supreme Court has said that that the death penalty is not an appropriate punishment for minors, even if they are remanded to adult court. So he was sentenced to life without parole, and unless there is some huge change because of an appeal, he was sentenced at 17 and he will be in custody for the rest of his life. Jennifer and James Crumbly are his parents, and they were accused of having been grossly negligent as parents. They were accused of knowing that their son had some serious mental health issues, and that they discounted them. And not only did they ignore them, but they bought him a gun. They bought him the gun that he used a week or two before the shootings. They bought him an early Christmas present and then took him out on the range and taught him how to shoot it. So there are some very serious allegations that go along with the Crumbly case. And it is a very high visibility case because it's a case of first impression. And a lot of people have reached out to me and asked me specifically about the defense attorney. My understanding is that she is more experienced and older than her demeanor would suggest in court. However, she comes across, the tenor of her voice is very young, and she kind of comes across as scattered and a little bit informal for this sort of a case. What I would say is cross-examination, the way I learned it, is cross-examination needs to be surgical. It needs to be laser guided. Cross-examination should be like a laser guided missile, honing in on those holes in the prosecution case. And it needs to be very methodical. It needs to be step A, step B, step C, step through the hole. That's the way that cross-examination should be done. The defense attorney has to tee it up, has to lead the witness down it, and then let the witness step in the hole. And that is not the way that she has been conducting her cross-examination. It has been much more like a shotgun, like, and I don't really know if that is, it appears that that's her individual style. that she almost does this like bumbling sort of Columbo sort of approach. I'm not sure that it has been incredibly effective here. And I am concerned that the jury has started to tune her out. She's made a few pretty glaring mistakes. So she made the comment on the record that that she doesn't have she's solo, she's alone, she's not doesn't come from a big office, so she doesn't have a lot of support behind the scenes while the trial is going on. And she also said she was struggling with the technology in the courtroom, getting her computer plugged in to be able to show her stuff. And then technology in the courtroom is never seamless, no matter how many times you try and you practice and you run through it, it's still never going to be seamless. We saw that in the Murdaugh case. I mean, I thought they had done an excellent job of setting up everything to run smoothly, and yet there were glitches. So it's always going to happen. That said, she was really struggling with it. And at one point, she just blurted out, because she couldn't get something to work, "Oh my God, I'm going to kill myself." What is that? I was, when I heard it, I was shocked. The prosecution jumped right in the middle of it the next day, bringing it to the court's attention and acting all outraged, which was annoying too. I don't love the prosecution in this case either. I think that they are heavy-handed. I think they have a slam dunk, and I think that they are the male attorney is very condescending to the female defense attorney. All of the things I don't like. Now, I will say I really like the judge in this case. She has been incredibly patient. And there were times today when she actually said to the defense attorney, "Ask your question this way." That should never have to happen. And I don't honestly know whether this is an attorney who is just so flustered, because she makes good points and she gets there eventually. I mean, it's a little painful to listen to her kind of stumble through it, but she eventually gets where she needs to go. I think it's just troubling that a judge has to say to her, "Why don't you ask the question this way," to get around the prosecution's objection. That should be something that attorney should be thinking through. Now, I realize this is a high visibility case. There are volumes of discovery. I mean, she was pointing to like 30 banker's boxes of discovery. I mean, it is a huge undertaking, even with support staff, to defend this kind of a case. So, and she does have other people there in the courtroom with her. There's another attorney at counsel table. There's a woman sitting behind her who appears to be her support staff. So, I mean, she does have help in the courtroom. But one of the things you run into when you are a solo attorney is, even if you have support, there are things that need to be done during the trial that only another lawyer can do, like issue last-minute subpoenas, or deal with an unexpected court ruling that a judge has given you, and having to go back and revise your cross based on it. Those are things that another attorney can help out with, and it doesn't appear there is another attorney on the case. So it is not a death penalty case. It is an involuntary negligent homicide case. And so it has different requirements in terms of court-appointed attorneys and all of those things. but I am concerned that this attorney really needs to take her ADD medicine. I have no idea if this woman's ADD. It just, she's so scattered and so easily flustered that she really needs to take a deep breath, get her feet on the ground, and work her case and not let the prosecution throw her off, not let her get so flustered. Her objections are so unprofessional, I guess. I mean, I would never stand up in court and say, "Judge, please tell the prosecution to stop leading the witness." That's not what you say. Objection, Your Honor. Leading. That's what you say. But you don't say, "Judge, will the court please instruct the prosecution to stop asking leading questions?" That's not the way that objection goes. So, but that's what she said on more than one occasion. There was a very interesting exchange having to do with a pretrial ruling. Those of you who are watching the trial remember this because it was a little legal dance. And what had happened was Jennifer Crumbly was having an extramarital affair with a man who was a witness on today. The prosecution called him as a witness. He's a fireman. And she was having a relationship with him at the time that the crime happened. And there had been, the judge had, at the request of the defense, issued an order saying you cannot bring that in because it's prejudicial and it's inappropriate character evidence. It goes back to that excuse me, I have the hiccups, that 404B evidence of character or prior acts. Now, we often hear about prior acts in terms of prior crimes, but it doesn't necessarily have to be prior crimes. And so the judge had ruled that the issue of her relationship with this person, who they knew the prosecution was going to call as a witness to some text messages that had been sent back and forth, that relationship was off limits. And for whatever reason, the defense decided that they wanted that to come in. And I think she wanted it to come in because, oh, I know why she wanted it to come in. The defense claims that law enforcement, at the time that they interviewed this fireman, and he told them about his relationship, the defense contends that they said, you know, you aren't going to want your employer to find out about that, because if they do, you could lose your job, you could lose your pension, you could lose, you know, and you don't want to have that made public. And the defense felt that they were putting pressure on him to change his story. His testimony today was that that was not accurate. However, the defense wanted that information in order to call him into question and say, you may have altered your story because you were afraid of the consequences. They had to admit that there had been an extramarital affair. So the defense asked the judge to allow that in, and it clearly said, I'm opening the door on that information. And there was a bit of a back and forth about the prosecution wanting Jennifer Crumbly to the judge to inquire of her that she fully understood that she did not have an obligation to let that information out, and that she had fully discussed that with her lawyer, the pros and cons of it, before making that decision. So there was a bit of a back and forth over it. She wanted it in to sort of inoculate the jury about it, and also to be able to say law enforcement used that as a bludgeon to make this guy change his story. Now, he got up on the stand and absolutely denied that law enforcement had pressured him to change his story, or that they had in any way threatened his job, which was what the defense said. So I don't know that it did her any good to get that in. I don't know if it hurt her client either. I think that it's kind of irrelevant to the story. The boyfriend fireman was not at all involved with her son, didn't know her son. It was a very very clandestine relationship. And that she sometimes left work to meet him. She had a job that had some flexibility in the way that the hours that she was required to be in the office, and so she took advantage of that and met him during the day when she was should have been working. So tomorrow, the prosecution is saying that they may finish tomorrow, they may rest tomorrow, and the defense may take over. I know because the defense attorney has said she has witnesses that will be called. So I expect that they will take over once. If the prosecution rests tomorrow, she'll take over. I expect that the trial will go into next week, and we will see. We might get, I don't know. Depends on how many witnesses the defense has. They might even get closing arguments on Friday. The question is really whether Jennifer Crumbly was so negligent as to be criminally and grossly negligent. And it really is a fact the jury is going to have to weigh. What makes this case so difficult is the horror of the underlying crime. I think they have been as respectful as possible while still outlining for the jury what the weight of the underlying crime, because I think that goes to the negligence piece. Is it grossly negligent to overlook watering your plant? No. But is it grossly negligent to overlook your teenage son complaining that he's seeing demons in the house and hearing voices, and buy him a gun and ignore his pleas for help? That's a different, and the outcome of that is this horrific crime. So I think they have been cautious about exposing the jury to the horror of the event, but they have shown some video, and there have been witnesses on the stand who testified to the experience of being in the school when the shootings were happening. The vice principal's testimony was absolutely heartbreaking. She was shot in the arm, and her only thought was trying to get all the kids to safety and trying to administer aid to a student who was down on the hall. And I mean, the situation is horrible and heartbreaking. Does that in itself does not make Jennifer Crumbly grossly negligent. And I think it's really hard for a jury to separate out the absolute heartbreaking horror of what happened from what responsibility does Jennifer Crumbly bear. It's very clear that her son bore responsibility for making the choice to commit that crime. The larger question is, what responsibility did Jennifer Crumbly bear? Should she have? So I just noticed somebody in the chat said, why isn't the dad charged? He is charged. He and the mother and the father were both charged. He just hasn't come up for trial yet. She came up for trial first. They're both charged with the same crimes of being criminally negligent. But her trial came up first because they're severed. Probably wisely, because they're going to rat on each other and turn on each other. I'm sure he's going to try and throw her under the bus. So I don't. So I don't think that they are being unequally blamed. So, but the question for the jury is going to be, can you sort out the horror of the underlying crime and only focus on whether or not Jennifer Crumbly is criminally negligent, grossly negligent? So I think it will be interesting to watch. There I go, talking about interesting again, but it will be. I think this is new ground, and holding a parent responsible in these circumstances, then you wonder, is it going to be a slippery slope? Are we going to see more and more of these? I personally don't think so, because I think that that it doesn't. I think that most cases do not rise to that grossly negligent level where a prosecutor would bring a prosecution. I will say that this is a small rural community, and I think that these kinds of cases hit differently in smaller jurisdictions like Delphi, like Oxford, like Rexburg. So I don't know. I have not really at this point formed any sort of opinion about where I think the jury's going to go with this case. I really don't know at this point. And I don't always listen to the jury instructions when the judge reads the hour long of jury instructions, but I will be really interested to hear the jury instructions that the judge is going to give this jury, because it really is a kind of an unheard of case. I think I'm ready to take some questions. For anybody who's got questions. I know Jen, I see the stars, so I think we've got plenty of questions to ask. Hi, Claire. Question: how can the police keep you from entering your home while they're waiting for a warrant? If they don't have a warrant, how can they enter your house? This is a good question. So there is a provision in the law that allows law enforcement to enter a property for the purpose of securing it, meaning that they're going to get a warrant. The warrant is in process, and they want to make sure that there is no one in the home who is going to hurt them or hurt themselves when or tamper or destroy evidence. So they're allowed to go into the house, and this is what happened in Crumbly. They went into the home and they secured the home. They made sure there wasn't anybody in there. They got everybody out. They made sure that weapons were secured. But they cannot open doors, open drawers. They can't do any of that. The only thing they are there to do at that point is secure the property. And, I mean, the whole reason is twofold. You don't want people who are not authorized to be in the house to be in there messing around. You don't want people to get in and steal other people's property while you're waiting for a warrant. You don't want any of those things to happen. So they are allowed to go in and secure the property. Once they were sure there was no one in the property, no danger in the property, they left and they sat outside and waited for the warrant. And they did not let the Crumblys back inside their property. They're allowed to do that because they are allowed to keep people from messing around or destroying evidence. So, because destroying evidence is a crime, as we saw in the Vallow Daybell case when they were charged with altering, destroying, or tampering with evidence. So they're not allowed to go back into the property, and the court can secure that until the warrant arrives. If there was some problem getting the warrant and the warrant were not immediately forthcoming, I think the Crumblys would have had an argument to say, you can't hold my property indefinitely without a warrant. So it really kind of turns on the individual facts. But in that case, they knew that the warrant had been submitted, and they were just waiting for the warrant to be signed and delivered back to them. So, but that's a good question. It is allowed, but search and seizure is a pretty strict area of criminal law. You cannot enter someone's property, seize their property, search their property without a warrant. And now there are some exceptions, which I've always found a little bit, the police knock on the door and they say, we want to secure the property while we get a warrant. And so everybody needs to leave the property, and we're going to walk through the house and make sure there's nobody hiding with a gun in a closet. In the process, they walk into the back room and discover that there's a meth lab back there, or they're packaging drugs. And that is all in plain view. There are a couple of legal tenets that apply. One is that if something is in plain view, the police can seize it even without a warrant. The other thing is the doctrine of inevitable discovery. So the police will say, well, as soon as they got back with a warrant, we were inevitably going to discover the meth lab in that back bedroom. So it would have been discovered anyway as soon as the warrant got here. We just saw it because it was out in open plain view. So, but they absolutely cannot seize anything unless there is a warrant, and unless the warrant describes with some particularity what it is that is to be seized. So if they go into that room and the warrant says, we want you to go in and seize any evidence of kidnapping or human trafficking, including electronic devices and online presence and all of those things, and they go in, and in the process of searching that property, they find records on a computer of drug transactions. That's not covered by the warrant. They're going to have to go back and get a separate warrant to seize the information having to do with drug transactions. So And they're going to have to prove that they have probable cause for that above and beyond the fact they already found them, because you can't use what you found improperly as probable cause to get a warrant. So they're going to have to develop, independent of the information discovered on the computer, probable cause to expect that these people were also transacting drug deals. Hopefully that makes sense, because the warrant has to describe with particularity what it is that they are looking for and are allowed to seize. So these are all great questions, and I love it when you guys make me think and make me get in the weeds a little bit. Hi, Debbie. It is horrific, but again, he was charged as an adult and parents charged with responsible for a minor. Yeah, that's an interesting little quirk to this as well. He was charged and remanded to adult court and charged as an adult, but his parents are being held responsible for not adequately supervising a minor. So that's an interesting little quirk. I don't think that it completely discounts the idea that he could have made very adult decisions when he was not adequately supervised and had access to a firearm. But you're right, it is sort of a little bit hypocritical, isn't it? Either he's a minor or he's not a minor. In this case, they're saying, well, you had an obligation to supervise your minor, but now they've made he made a very adult decision and we're going to prosecute him as an adult. So very good point, Debbie. Sorry, I'm already getting a little croaky. It was you can go ahead and put it up. I'm just chatting. It was almost 60 degrees here today, which after it being in the teens for weeks, a couple of weeks ago, is a welcome change. But it was also really windy, and that always kicks my allergies up. So forgive me for being a little croaky. Hi, Pixie Pancake. Love that name. Of course, I like pancakes. If jury tampering aided the prosecution, would the prosecution be tasked with proving that the jury had been tampered with? It seems like a conflict of interest. This is a good point. If the jury was tampered with, it is shifting, as you say, shifting the burden of proof by saying we're going to presume prejudice, and now you have to prove you weren't prejudiced. Shifting that burden, I think, does create a conflict for the prosecution, because now they're having to prove that their process was biased, and that as a result, the defendant was prejudiced, or they're having to prove that their process wasn't biased, and so there was no harm, no foul. It was harmless error. So, but that's a good point. The law is full of interesting little quirks and contradictions, like we're charging you as a minor, but yelling at your parents and holding them responsible for not supervising you as a minor, even though we're charging you as an adult. This is another way that there are contradictions. So it makes tremendously more sense to say to the defense, if you think your client was actually prejudiced by some misconduct at the jury level, it's up to you to make that case and to prove that. Now, it's not beyond a reasonable doubt. You don't have to prove beyond a reasonable doubt. You only have to prove by a preponderance that the jury tampering happened. But it's still the defense's responsibility to prove that there was actual prejudice. That's what Judge Toll ruled was going to be the law that was applied to it. So, hi, Jane Blackbird. Question. Don't the original Richard Allen attorneys have a reasonable expectation of privacy in their office and not be dubbed incompetent by the judge? I think this is absolutely the case. And I think this is the case that was made by everyone involved. This was the person who actually took pictures of the evidence and disseminated them was a person who was a visitor to the office, was an invitee basically, and certainly um, Rosie and Baldwin had an expectation that a visitor was not going to go nosing around in their conference room in their evidence. They absolutely had that expectation. And in fact, that person has been charged criminally with stealing that information. So I believe that there's absolutely no way the prosecution is going to be able to prove that they were in willful contempt, that they actually did something to further that person getting access and disseminating that discovery material. I just don't think the prosecution can get there. I think it was filed purely for the purpose of harassing and getting revenge, and it's just pure harassment. It's taking up these lawyers' time when they could be representing and defending their client. And I think it's kind of a low blow. But this is a case where we have repeatedly seen this power struggle going on. It is a power struggle. It is a pissing contest. And I just, I don't have respect for the prosecution or the judge in that case, because I think that they have let their egos and their emotion get the best of them. And I worry that's what's happening in Crumbly as well. I think that I think that the defense and the prosecution have had some long-standing animosity and friction, and I think that it's coming out at the trial a bit. And the judge, who is a very patient and very able judge, she reminds me a little bit of Judge Newman in the Murdaugh case. She is doing a terrific job. And I think she's doing a really good job of moderating and mediating some of that. But I do think that the defense attorney really needs to take a deep breath and get one foot on the floor. There are times that I've been watching this and I'm just like, oh, girlfriend, that is not the way you get there. And so many times I've just seen her be scattered and unpolished, and that is not the way you want to appear for your client in court. You really want to be that voice of reason, that voice of sanity, that voice of, yes, I understand that I am telling you that the prosecution may not have the full story, but I'm doing it in a way that is so professional and so sensitive that you can't help but think, okay, maybe she's got a point. If you go into court and you grate on the jury's nerves, that doesn't do your client any favor. And I think sometimes the defense attorney in Crumbly is kind of getting there. But I'd be really interested to hear what you think about her performance, because I've had several people ask me what my thoughts are. So I think she needs to nail one foot to the floor and really settle in to her defense and not let things flummox her quite so much. She gets flustered, and you just can't get flustered as a defense attorney. You have to be sort of the Tin Man, you have to be like, You just don't let it, you just got to let it roll off like the proverbial duck. You know, I love the description of a swan who is moving gracefully across the pond, and under the water, they're under there just swimming like heck. And I think that is a very apt description of a defense attorney's job. Never let them see you sweat. So, what do you all think? Hi, Mary. She's getting on my nerves so much, and I only have one left, so she's pushing the limits. Yeah, I know. It is nerve-wracking because I think the reason I find it nerve-wracking is because she makes some good points. If she could just calm down a little bit, and I hate it when people tell women lawyers calm down, or I hate it when women get justifiably mad and people say, oh, calm down. So I don't mean to make it that way, but I think that she just needs to center herself in her case. I mean, I don't know how many times I would stand in the bathroom before a trial started, and I would think to myself, you know this case. Nobody knows this case better than you do. You know this case. You have prepped this case. So go in there and represent your client because you know this case. Go in there and show that confidence. And I don't think that she's giving her client a great sense of confidence. And I don't think she's giving the jury that either. And that's unfortunate. But then whatever she does, she's still better than Dick Harpootlian. Sorry. I think the last, Claire B says she thinks it's a ploy to lead to a bad attorney appeal to an ineffective assistance of counsel. You know, I have said over and over again, ineffective assistance of counsel is a very high bar to meet. She has been effective counsel, so they are not going to get an ineffective assistance of counsel appeal. It's not going to happen because that bar is high. You have to be able to show that but for your attorney's poor performance, you would have been found not guilty. That is tough. I mean, it's very difficult. Even in cases where we have lawyers who have violated their ethical obligations, who have slept through their trials, we have courts saying, yeah, no harm, no foul, because you would have gotten convicted anyway, because the evidence was overwhelming. So I will say about this last hearing on Murdaugh, it was the first time I have seen Dick Harpootlian actually act prepared since the early days of the trial. So I will give him that much, but he's in the sunset of what could have been a very celebrated career, but he has thrown it all away on Alec Murdaugh, and I don't know why. I don't know why anyone would ever sacrifice their lifetime of work, the reputation that they have built over a lifetime of work for somebody like Alec Murdaugh. But that's South Carolina for you, and that's South Carolina good old boys. Now, Justice Toll did say in that case that she had no confidence in Miss Becky. She thought she had been committed misconduct, and I think we're going to see a lot more of the consequences of Becky Hill's behavior. So. Hi, Tiff Knox. If Ethan committed his crime one day after he turned 18, would his parents still be liable for buying him the weapon? Nope, because he would have been able to legally possess it. Well, let me say, if he were at the age that he could legally possess a handgun. Now, it seems to me I heard some testimony in Crumbly that there are limits, age limits on when you can own a handgun, and it may be 21. But if he was at the legal age at which he could own that handgun, they would not have been liable. Mm-mm. Nope. It is purely because he was a minor and he could not legally own that handgun, that they are contending that they were grossly negligent. Now, they're also contending that they were grossly negligent in not securing the gun. The testimony was that that the Sig Sauer came, the gun that was used came with a case and a cable lock, and the case was set up so that you put the cable lock through the trigger mechanism and the case, and you make the gun unable to fire. And then it is secured inside the case. The testimony was that it was not secured. The cable lock was separated from the case, and it is always best practices to separate the bullets and the gun. That wasn't done, and Ethan had access to it. It wasn't locked up, and he was able to go and get the gun. Regardless of whether the gun was secured, he knew where the key was. But it wasn't locked up, and the combination was still set to 0. So it had never been, a combination had never been set on the case, on the gun. What they call a gun safe really is, a box. So if Ethan killed people by mowing them down with a truck, would parents still be charged for buying him the vehicle? I think this is a really good question. I think that I think the answer is maybe, because a vehicle is considered a deadly weapon. So I think maybe, but I think you make a good point. The only thing I would say is that what argument might be made is that if they bought him a vehicle and he was legally licensed to drive that vehicle, so he had a legal operator's permit, a driver's license comes with certain rights and responsibilities. And one of those is to operate the vehicle safely. And that would be different because he could not have legally operated the gun, if that makes sense. He could have legally operated a vehicle because he had a driver's license. The fact that he drove that vehicle through a crowd and was charged as an adult would not necessarily be as foreseeable, let's put it that way, as it would be for a gun that he was not legally authorized to own and operate. So they did make the point that parents could allow people underage to operate firearms with parental consent, but under the law. So she took him to a firing range and they shot guns. Dad took him to a gun range and they shot guns. So there was that distinction was made. But I think the way that the defense would get around that car versus gun would be he had a license to legally operate a vehicle. It wouldn't have been possible for him to legally operate the gun. So I'm not sure it works, but I think that would be the argument. What happened to the pets in the house being searched? If what happens to pets in the house being searched if owners can't come back in? That's a great question. In the Crumbly case, there were two cats and a dog, or two dogs and a cat, one of the two. And the police were cautious not to let the animals out. And the Crumblies were able um, to I there was talk about the animals, and I think they were able to either take them out or have somebody go in and take care of them. I can't remember, but remember that when the Crumblies were when the police came in and secured the house and made them leave and then got the warrant, they were at the house and searching and seizing evidence for some period of time, but the Crumblies were allowed to go back into the house once that search was done. Once the warrant was served, they were allowed to go back in. And it the bigger question for Jennifer was when she got arrested, she had to have somebody who would take care of her pets. But she was able to get somebody to go and do that. So, I mean, I've had cases where warrants were served where there was a child in the house, and the police stood by until child welfare came and removed the child so that the search could be done. So it's the police have a responsibility to secure the living creatures in the home. So. Good, Lori, is the quilt on its way? I want to watch for it at my door. It is in a box at my feet, and I'm going to drop it in the mail tomorrow. I'm going to take it down to the UPS store and ship it out. So you should start looking for it. I was going to send you an email once I knew it was on its way with the tracking number. Greg? Do you think Becky will lose her job since she obviously perjured herself? Yeah, I don't think she keeps her job. The interesting thing is, now I will say this, the interesting thing is that there is no mechanism in South Carolina, and I think this will likely change very soon, to recall the clerk of the court. So that is an issue, and I am certain that the county commission is probably looking very long and hard on a process for recalling her, because she was an elected official, remember, and but I doubt seriously, even if she is not removed from her job immediately, I doubt seriously that she will be allowed to go back to work, not with some of the things that are going on, because there was much more than just her comments to the jury. There are also allegations of misappropriating money and currying favor or trading favors, those sorts of things. So hi, Jacqueline. I don't know. My understanding is she's a county elected official. She is the Colleton County Clerk of Court. So I believe that the county officials are the ones who have to figure out a way to recall her. Now, there may be something in their in the state statutes or in the county rules that say that a person who commits a crime, an elected official who commits a crime, can be removed. So if she's charged with a crime, it may change whether or not they can remove her. But she's done one way or the other. She'd be smart to resign. But we'll wait to see what happens. I think right now she's on paid leave, which may be why she's not resigning. But I think that's going to be short-lived. Hi, Carrie. Where is the money coming from for the Murdaugh defense attorneys? Is there not a way to find out how an attorney is getting paid? Seems any money Alex Murdaugh has should be paid to the victims and not his defense. So as far as money coming from assets that belong to Alec Murdaugh, um, they they have not been permitted to be used. At one point, he had an IRA or a 401k or something that his attorneys asked to be able to invade for attorney fees, and the judge allowed some money early on to be used for his attorneys. And the last time they asked for money, the judge said, "Nope, sorry, you don't get any more." We don't know whether there are others who are supporting Pootie and the Grifter, or whether they're actually at this point just feel like they've been paid enough and they're going to stay on the case. I don't really know. Um, it, Dick Harpootlian doesn't seem like the kind of person to me who works for free, but we also do not, as I've said before, we also do not understand that whole good old boy network and what sort of power the Murdaugh family still has in South Carolina. So, yeah, we don't know. Hey, Mary, what do you think about the judge saying in Alec Murdaugh saying from the evidence she saw Alec Murdaugh as guilty? Oh, yeah, she did. She did say that she felt that the weight of the evidence proved that he was guilty, and that she didn't believe that the jury had brought back an unfair or unjustified verdict. I think that's perfectly appropriate. She also said that she sat down and read all the transcript of all 6 weeks of the trial. If anybody is in a position to say that, she is. And so I think it was appropriate for her to say, having reviewed that in preparation for this trial, I don't believe that there was undue influence, that he was prejudiced. And I do see that the weight of the evidence was that he was guilty. So I think she tied it together that way, which I thought was okay. Hi, Carrie. Question. In the Chad Daybell case, could it come up that Chad called about Charles's remains? Oh, yeah, that came up at Lori's trial. And he wasn't even on trial at that point. So, yes, it came up as part of the conspiracy. Even though he was not charged with conspiracy in Arizona, it did come up in support of the conspiracy in Idaho. And it certainly will come back. Yeah. For those of you who don't know, Chad called, gave I don't know, half fake name, and called the funeral home where he called a funeral home asking about the prices of having his uncle who had died cremated and the remains shipped to Louisiana. So it's clear that at least at some point, even if it's after the fact, he was involved in the conspiracy. And that was offered at Lori's trial. So I'm sure it'll be offered at his as well. Hi, Claire B. What was the issue when Jennifer's lawyer asked a police detective if they were aware they were in the process of making a deal to turn themselves in with the prosecutor? I think the reason she did that is because their flight can be used as consciousness of guilt. So the same way that anybody else would be, as my brain just lost the name. The woman who killed the bicyclist. The same way as her running to Costa Rica was used, or the Adelsons buying one-way tickets to Vietnam was used as consciousness of guilt. She's trying to sort of blunt that by saying we had a plan for them to turn themselves in. They weren't fleeing because of consciousness of guilt. This is the point she's been making all along. They were receiving threats through social media and through text messages. They were receiving death threats, and they were afraid for their own safety. So the point she's been making all along is they were not hiding out because they were afraid of, they didn't want to turn themselves in and be arrested. They were hiding because they were afraid for their safety. And to prove that, we're gonna talk about the fact that we talked about them turning themselves in. Their lawyer made overtures to get them to turn themselves in. So I think that was the point of it, was just to sort of blunt that consciousness of guilt. They were on the run. It doesn't work so well because there's a text message she sends to the horse barn, to the woman who runs the horse barn, saying we're on the run. So, you know, I mean, I suppose her defense attorney can argue that doesn't necessarily mean we're on the run from the police. They were on their run from death threats. Good questions tonight, guys. How do you think they accessed that building and art studio? They got a warrant, and the police, the officer that was on the stand today, went into how they accessed it. It seems to me that they just went in through the door. Either it was unlocked or they forced it open, but they went in with a warrant for that building. K2 Chi? Doesn't the federal court have the right to refuse to take Alec Murdaugh's case for a new trial since he's lost in the state trial? And yes. So the federal court, in order for there to be a federal appeal, there has to be a federal issue. There has to be some violation of the U.S. Constitution and an issue of federal law. And even at that, the Supreme Court can decline to take a federal case. And the federal appeals court, usually at the appellate level, the federal appeals court would just say, we affirm without opinion. And but the U.S. Supreme Court can decline to take cases, and they do all the time. They only take about 1% of the cases that make it to a federal Supreme Court filing. So absolutely, it's no more than 50-50 that they're going to get anything out of the appeals court, and out of the federal court, less than that. Are you going to do quilting videos again? You know, I would like to. Now that my book is off at the publisher and I'm working on launch and marketing kinds of work right now, I would like to. I have said all along that I would like to do a project where we each do a square, and that square becomes a quilt for the woodcocks. I've tried on a couple of occasions to get access to a quilt pattern that I wanted to use. Haven't been able to do that, but we may just tweak the pattern enough that we can use it, because it is a folded crane, like an origami crane. And in Japanese culture, folding 1,000 cranes is a way that you remember someone in memory of someone. So I thought it would be really fitting to do a crane quilt. So I will continue to pursue that. I'm also thinking of doing a raffle quilt for CRIMECON. So I'm hoping that I'll get that project underway soon. And then we'll be able to raffle it off to people who make it to CRIMECON. Because I enjoy doing it. I like instructing, and I always like teaching quilting. So any other last questions to wrap up? Arcana Mystery. Crumbly lady has made herself look very old and unappealing. Do you think that is a defense strategy? Thanks. In part it is. In part it is. Jail is just rough. When I looked at the videos of her police interview and then looked at her now, I thought, whew, jail has not been kind to her. She's gained a great deal of weight. She looks very puffy and she looks very unhealthy. And I don't know that that's something that you can manufacture, but I just think that jail is a very inhospitable place. And so it's no surprise that she doesn't look as good as she used to. But certainly, I mean, it's always a trial strategy to dress your client very conservatively, to if they wear glasses, get them in their glasses, hairstyle, very conservative. And it certainly is always a trial strategy. Recently, I can't pull up the woman's name now, but she was prosecuted for abusing her special needs son. She came to court every day in Pippi Longstocking braids. And I think it's a trial strategy, and certainly sometimes it works, but sometimes it doesn't. I think that sometimes jurors see through that. Lisa always, will you move after Chad's trial or stay in the area? I have some news about that, but I'm not 100% prepared to make announcements yet. But I think we will be moving to be closer to our daughter. So more to follow, but for now, I don't anticipate that we're going to stay in Idaho long term. So I think within the next year. Hi, Lisa Joe. Thank you. I enjoy the education and frustration with the legal system. Well, I try and be honest because I still believe that we have the best possible system. I still believe that with all its faults, our system is still the best one. But I think that you don't change something by standing on the outside and stomping your feet and saying, boy, is that messed up. You change things by getting inside and being part of the solution. And so whether I am writing books or whether I am practicing law, I feel like it's my responsibility to be the change that I want to see. And so I think it's important to point out where the warts are, because that's how we fix things. We don't fix things by just pretending that there's nothing wrong. And I think that's true in a lot of jurisdictions, especially South Carolina. I think casting sunlight, whatever you may think about any of the creators down there, and I know that there are huge schisms about what people think about some of the creators. I personally think that Mandy Matney and Liz Farrell have done a really good job. I've been following them since the early days of their podcast. I think I think I caught the first 10. But I understand that there are a lot of other people who have varying opinions and think other outlets are more credible. But I think regardless, the attention that has come to South Carolina has brought attention to the issues of corruption and the issues of cronyism and the good old boy network down there in a way that has never been done before. And I think that's an important part of strengthening and refining our system. It's not enough to just sit on our laurels and say we have the best system. That's how systems break down. We always have to be looking toward making it better, making it fairer, making it more accurate. So I enjoy that. I love that you all come along with me on this journey. I love talking about the law and doing a little teaching. And I love that you all are here with me. Yes, wristbands are still available. I would love to see us flood social media with pictures of people wearing wristbands during Chad's trial. And so please drop me a self-addressed stamped envelope if you would like a wristband. There's a lot of interesting information in our show notes, a lot of connections and links to other stories, to other creators who are talking about different stories. So take a look there if you haven't looked at our show notes lately. And, you know, Jane, I think that's true. We got to deal with inflated egos in law and Congress, and that's my hope. Yeah, I think that I like to think that as we change generations, that we're bringing more people, more women, more people of color, more diversity into the practice of law and into our governance, and that's healthy. That we really need to retire some of the old white men, and it just is a reality of the way our generations go. We need to turn over and bring new ideas and fresh perspectives in. I do believe that the increase in women in the legal profession has had a positive effect on the profession in general, and on the way that people practice law, and on the way that firms operate. All of those things, I think, have changed with the increase in women in the profession. And I think that we have seen some real movement toward more inclusiveness, people of color, LGBTQ, people with, how do we say this, interabled, people with varying physical abilities, all of those sorts of things. I think that as we have seen those folks come into the profession of law, I think that we're seeing change. But let's be clear, law is an area that changes incrementally slowly. We're all about precedent and all about rule, and that by its own nature makes it a very difficult system to change. It's like turning the Titanic, you know, we're not speedboats. And so I think that given time, that we're going to get there. And I love that I can be just a little bitty part of it. And I love that you're all on this journey with me. So, any last questions before we go? Please subscribe to the newsletter. I will say that we haven't gotten a lot of newsletters out recently because I've been writing a book. But there are a couple of issues that I would like to do a little bit more of a deep dive into. And that's the place where we really get in the weeds and talk about the nuances of the law. I want to thank Jen, who is our moderator tonight and has been our moderator for the last few weeks. I want to thank you all for joining us. I know that you could be spending your Wednesday night any old way, so I appreciate that you're spending it with us tonight. And I'm going to say thank you and good night.